Hi, I'm Mark Mifflin. I'm a member of the Legislative Committee of the Illinois Association of Defense Trial Counsel. I'm here today. Today is February 20th, 2018. I'm here to provide you a brief legislative update and to provide you some information about two proposed significant rule changes for Supreme Court rules. First, let's talk about the legislative update. Just a reminder that the Democrats control both the House and the Senate with substantial majorities. But of course, Governor Rauner is a Republican, so there's kind of a standoff and a constant conflict between the legislature and the governor. The spring session of the legislature is just getting underway. The bill filing deadline was last Friday, so we've got a significant number of thousands of bills filed that we're trying to sort through at this point. But the action inside the legislature to this point has been pretty quiet, and we expect that it will remain quiet until after the March 20th primary. There's a limited number of legislative days prior to the primary because the legislators are focused on re-election. One of the bills that we are following, we asked Senator Bill Brady, the Senate Minority Leader, the Republican from Bloomington, to introduce for us. It was Senate Bill 2449. This is a bill which we have filed before, which deals with joint and several liability, and it would require that all tortfeasors be placed on the verdict form for the determination of fault for the defendant like they are for the plaintiff. And it would also eliminate the requirement that the jurors be advised that a 51% finding of fault against the plaintiff will bar recovery because they're not told that a 26% finding of fault against a defendant will cause joint liability. Both of these provisions are designed to level the playing field between plaintiffs and defendants in that context. A little side note, Senator Kwame Raoul, a Democrat from Chicago, who's the chairman of the Senate Judiciary Committee, has placed in some of his ads the idea that his public service has been aimed at leveling the playing field in litigation. And also, there's various op-ed pieces from the trial lawyer president over the last couple months that have indicated that the trial lawyers are seeking to level the playing field in a litigation context, and both of these ring hollow. And the best example I can give you that is that Senator Raoul has, as the chairman of our committee, of the Judiciary Committee, has placed our bill in a subcommittee, what will probably never be called for a vote. So we're not even going to get a vote on our bill unless Senator Brady can work his magic and get it called for hearing. So we're hopeful that that will happen, but we're not sure that will happen, and certainly Senator Raoul is not helping that to happen. There's a lot of other bills that we're following, some of which will become important and most of which will not as the legislative session progresses. There are two significant work comp bills. There are a lot of work comp bills, but the two significant ones you may have seen before. One dealing with a state fund, a state-funded insurance company is really what it amounts to. That's been filed in both the House and the Senate. And there is a more substantive work comp bill dealing with insurance rates and with some benefit provisions that's been filed again in both the House and the Senate. Both of those were passed last year in the House, and they were held up. In fact, Governor Rauner had to veto one of those. We don't know whether that will happen this year. We're optimistic that the governor would veto those if they passed, and they might pass them just to make him do that during an election year. But we'll continue to monitor those and work against those. The other examples, I said there's a lot of other work comp bills. There's some venue bills. There's another joint and several liability bill. There's a bill to reinstate the public duty rule. And there are several administrative procedure bills dealing with the procedures in the appeals administrative review. We don't expect much controversial action on our issues until after the November election, probably, because the Democrats, if they pass legislation, will not want this to be an issue in the November election, just like they won't in the primary election. We think that the focus for now in the legislature will be upon the budget and implementing a budget before they go home at the end of May when the spring session ends. They won't come back then until after the November election in all likelihood. So that then they'll be free to do more, have more substantive activity without the influence of the election hanging over their head. I also want to note, and you probably read in the paper, that there are several sexual harassment allegations in Springfield, in the Senate and the House. These have had a chilling effect on the legislature. and everybody is walking on eggshells because of all the notoriety that has occurred, and everybody's kind of waiting for the next shoe to drop in this context. So it really is having a chilling effect. I just mentioned that to you because there may be some action on that front, just to make it look like the legislature is doing something, but that may also chill action on some of the other subjects. I want to point out to you too that all of the bills which we're following are listed on the Illinois Defense Council website under the legislative section, and that's in the advocacy section. So you ought to be able to find those on the website. If you have any problem, let us know and we can direct you how to find those. And you can not only see what they are, but you can see how they progress. Those are updated regularly by Sandra Wolf. Now, the Supreme Court rule changes deal with depositions and the use of depositions. The first proposed change is from the Illinois trial lawyers again, and it would allow the parties to use any part of a deposition as substantive testimony at a trial. Right now, the rule is that they can use the entire, if they use any part of it, they have to use the entire deposition, kind of the rule of completeness. We are opposed to the trial lawyer's proposal to use any part because we think it would allow parties to use just snippets of depositions, maybe even taken out of context, and then the other party would have to respond and probably introduce the whole deposition or introduce other parts of the deposition, and it would just complicate further. We don't think there's any problem with the current rule that follows the rule of completeness that requires the complete deposition to be read if any part of it is to be used. The next proposal and last proposal that we're following is number 1712, and it would eliminate the distinction between evidence depositions and discovery depositions. We believe that this would substantially impact how defense attorneys proceed with discovery depositions now. We're on a mission to find out the facts, particularly a doctor is probably the best example. Because of the Petrillo rule, we can't call the doctor and talk to the doctor before the deposition. So at a discovery deposition now, we're free to ask the questions to find out the facts. If this rule is changed to eliminate the distinction between evidence depositions and discovery depositions, then we would have to ask these questions that we don't know the answer to at the deposition, and then that can be used against us at trial. In many instances, when we're trying to find out the facts, we may ask questions which are detrimental to our clients. So we would then have to go back and do other things to compensate, such as calling that witness for personal testimony at the trial. So we think this is also a complicating factor. It will not expedite discovery and expedite the trial as designed. We think it would further complicate those issues and would prove unworkable. There's also some interplay with the federal rules, which they're cherry picking some of the federal rules provisions and applying them to ours, which is in a completely different context. This is a significant issue. We are following this. The IDC has prepared a substantial memo about both of these issues, which will be submitted to the Supreme Court and is being submitted to some of the other groups involved in this. That provision, that memo will also be available on the website. In fact, you may get some emails about this as it progresses, because we do think that this is especially significant. And I would be remiss, there are several people from the IDC, probably 15 or 20 people from the IDC have been involved in reviewing and commenting on this rule, but Pat Eckler from Pretzel and Stouffer has done yeoman's work on this issue and putting the whole thing together. So we appreciate his work. So check the website. We'll get back with you with a new legislative update with a video when things have changed and sorted themselves out even more. And we will continue to follow all of these bills. If you have any questions, let us know. That's what we're here for. Thank you very much.